I have pressed the record button, so we are now proceeding with a public deliberation for case number CBA 22-050. This is an appeal of the administrative law judge's approval of a development plan in the matter of 1500 Merritt LLC, that is 1440 Merritt Boulevard in Baltimore County. We previously heard oral arguments from Mr. Rader and also Mr. Vittori, who was representing the developer in this matter. I believe during the hearing we had some Rule 8 discrepancies or such, but there was mention of the Norwood, I think, Hollerberg Community Association, but Mr. Rader was able to testify on his own behalf and his concerns also that affected the community. For those who might be watching or unfamiliar with this process, this is a public deliberation pursuant to the Public Meetings Act, meaning that prior to COVID, the three board members would be sitting around a table in a room at the Board of Appeals. The public would be invited to view and listen as we deliberated these matters. But after the end of the hearing, there's no more participation in the deliberation other than the three individuals of the board. So folks who are joining us today by WebEx are free to listen to our deliberations and our reasoning for our decision, but no further testimony or commentary from the general public or council is permitted at this juncture. This is a development plan appeal, and what that means for this board, other than other zoning matters where we hear them de novo, meaning that basically it's a start over and we take new evidence and make our own findings of fact. This appeal is pursuant to BCC 32-4-281 for record appeals, meaning that basically our duty here is to look for errors of law, maybe arbitrary and capricious findings, or things that went beyond the power of the ALJ in making their decision. As this was a development plan situation, there are specific rules for the review of a development plan. They're outlined in a case called Elm Street. Basically, we don't find new facts. Basically, we're fact finding. We defer with, or at least give great deference to that of the ALJ. And I mention that because unlike many of the development plan cases that we often hear on appeal here, we're not really dealing with factual disputes per se as to things that went before the ALJ, situation being that there was no opposition at the ALJ level. There really wasn't much argument that there was not a prima facie case made by the developer and through the county agencies who approved this plan. So I believe the issues that we're dealing with here today are a lot of procedural issues that were brought up. And if I could start at the first procedural issue that was spoken about at the hearing, I think we kind of ruled on it, but I guess it's worth going through again just so we have it on the record, is whether or not the actual notice of appeal was in compliance with BCC 32-4-281. I believe we ruled upon that in our hearing and found that there was at least sufficient compliance. It was within a day. I think the arguments that were made that it was sent to the wrong office, meaning that it went to OAH instead of to the board and PAI. As I do recall, the three of us found that we were allowing the appeal to go forward, and we found that, I guess, enough compliance that notice was given to the developer to respond. Am I right in that assumption, gentlemen?
I don't recall that, actually.
I don't recall that either. I think I got the sense we reserved on that.
Right.
Okay, so we reserved completely on it. So
I think so.
okay,
I
well,
think so.
well, I know we let the hearing go forward, so at least
we did
reserved.
that. Yes. Yeah.
All right. All right, so the issue is still right then, and it has been raised. And factually, I'll go through it again. I guess the appeal was filed on the 29th day within the 30 days.
Well, it was actually filed on the 31st day.
Yeah. Was it? I thought it was the day before.
It was the 30th day fell on a Sunday. So,
Okay. Oh, then,
so it was
okay,
filed on Monday, so it was
Right.
actually, I mean, it was within 30 days,
Yeah.
but it was actually the 31st day.
first. I get you there. I think
Okay.
the issue was where it was filed.
Correct.
Yeah.
Right.
And being, and it was sent, I think it was CC'd to the council, went to the county executive, went to, OAH, but never went to PAI nor the board as is required, I believe, in subsection B of the appeal statute for that.
Right.
I guess, so let me start over talking about what I was talking about before this. In my thought on the matter is that I think these cases are very fact specific. I wanted to first say, just because a pro se person makes a mistake doesn't make it a mistake that gets you over the hump of what is required. So there is many circumstances where pro se folks made mistakes and nobody's, basically giving them a pass. In this situation, the way I look at it is there was a substantial compliance, significant compliance. It went to the wrong place. I can say many of the issues that were raised in the appeal, procedural issues, as we heard in oral arguments, were issues that the Developers Council was prepared to discuss at the hearing itself if there would have been attendance. So my view on it at this point in time, I'm interested in what you two have to say, is that being that the reasoning for the notice of appeal is to give the other side an opportunity to be prepared to refute allegations. Though there is a mistake in where it was sent, I don't see prejudice that would warrant us not discussing the other parts of the appeal. And that's my thought on the matter.
Well, I certainly want to discuss the other issues.
Yeah, well, I mean, that's just the first issue. Before we can
Right,
get to
right.
any other issue, I just wanted to do that issue.
Right. My view is a little different than yours on this. Of course, I'm oftentimes willing to give the benefit of many doubts to community groups and to people who are acting without counsel. Here I'm not, actually. I mean, so it was sent to the wrong place. It was sent to OAH, and OAH forwarded it to the Board of Appeals. There's a question about whether that constitutes a filing, but if that's what we were dealing with, and it was 30 days or 28 days or something, I would cut them a break on that. I'd say, well, they filed it in the wrong place, but OAH forwarded it to the right place, and so that's sort of tantamount to filing. I would that's a construct I'd be happy to live with, frankly. But here I'm not actually, because they tiptoed up to the line, and all you have to do is read the statute. I mean, you don't get a pass on just doing what you want. I mean, you can, when you don't retain counsel, you run certain risks. And one of them is that you screw up the procedures. And many times, community organizations can't afford counsel, but you know what they do is they call other community organizations, and they get information from them about what to do and how to do it and what to look at and all these kinds of things. They don't just do it for whatever reason. So as one alternative in this matter, I personally would rule that the appeal should be dismissed because it wasn't filed within the timeframe. I'm trying to dredge up in the recesses of my mind. I think, I want to say that failure to file an appeal on time is a jurisdictional defect. I seem to recall that sort of backs, but I might be wrong on that. So I'm not prepared to say it's jurisdictional to miss the time, but I do not, I'm not willing to give anyone a pass in this case. So for whatever it's worth.
Well, based on that very candid response from Mr. Evans, I'm still open to thought on the matter, and I'm going to defer now to Mr. Lauer.
Thank you. I also had some problems with them filing with the wrong office. I am sure that someone in the county, if they had picked up the phone, or Mr. Rader, I believe, was his name, had picked up the phone and asked them, where do we file this thing? Either the ALJ's office or Office of Administrative Hearings or someone in the county would have said, hey, you file it with the board. That's one thought. The second thought is this precedent setting in any way? Can we go from here? I know that there's no precedent in our hearings and our rulings and those things, but I mean, just in my own mind, where does that leave us in terms of opening the door? I'm not as concerned about the 30 days and whether it was a Sunday or a Monday, and I think it was the 4th of April and then the 3rd of May, or it was 30, whatever. I'm not as concerned about that. My concern is, what if someone takes it to the Office of Planning next? Where does that leave us in terms of, if this same panel, and we all remember, which I may not, how we proceeded in this matter. So I think there was an opportunity to get the information from the county. I think it would have only taken a phone call to the ALJ's office to say, look, I'm going to appeal this thing. Where do I file it? Or to the Office of Administrative Hearings, or to the permits, approvals, and inspection office, or any one of those characters, or the Board of Appeals, So that's kind of how I ended up with in terms of my at least initial thinking with this, and would open to.
Well, Mr. Lauer, and Mr. Evans, and since we did hear, we reserved, and we had to reserve, or we wouldn't have had a hearing. So, we had the hearing, and in the hearing itself, and I think I had asked questions during the hearing that kind of shed more light on this, is that there was some initial confusion as to procedure, but there were a lot of steps along the road where folks, through further investigation, could have found themselves, one, learning the procedure for an appeal properly, and two, finding out when other certain steps might have taken place where input could have taken place as well. So not to belabor this point, the two of you seem to be steadfast. I was in the midst of wish and wash, but but due to your steadfastness, and the purpose of such deliberations in this situation is to share opinions with each other and to inform each other of opinions. I would have to say my wish and wash would point to joining you two in a more strict compliance. As I said, that there is not always a Well, there's never a free pass for pro se. There's things that matter and things that do not. I hear Mr. Lauer saying we have a slippery slope situation here, saying we have rules for a reason. If we deviate, what would be next? And Mr. Evans saying that basically there was a waiting up to the line. Lawyers, at least this lawyer knows, if you file something a week before the deadline, if there's a mistake, you can usually fix it before the deadline arises. That's why you file it a week before, out of paranoia that such thing might occur.
Right. I always did. That's what I would
Yeah.
do.
And
Yeah.
there has been a bit of cavalierness in adherence to deadlines and rules for participation. Um, we often fault the code for its muddy nature for consumption of both counsel and pro se folks. But as Mr. Evans put it, the statutory guidance of what you're trying is plain in its meaning, and it's not using grand legal terms. It's basically where you send things. All right, so on that issue, which is basically the threshold issue, I guess we are in agreement. I know, Mr. Evans, you would like to address arguendo, I guess, the other issues just for completeness. Um, what I would like to do is work backwards quickly, and first issue to deal with before we get, I know it's out of sort of sequence, is the chronology for the notice for the hearing at OAH. That one. We got two different notices here. We have a CIM notice issue that was raised, and we also have the issue for the ALJ hearing themselves. They are separate and apart because there's different statutory requirements for each, for requirement for the actual hearing notice. So bringing up the first one, and which is, I believe, BCC 324227B7, dealing with the required posting that is to be done prior to the OAH hearing. The record reflects, I think it was on 3/3/22, we have Ms. O'Keefe doing the original two signs. Email evidence also showed that evidently Ms. O'Keefe went back on the 28th of March, which was the 5 days prior to the 31st hearing, found that a sign was no longer there. A new sign was replaced on the, I'm sorry, it was replaced on the 27th. And on the 28th, she had some email contact with other folks for clarification of, where to put these signs, either in the thoroughfare in the middle of Merritt Boulevard or closer to the Wendy's entrance. And those things were done. Counsel for the developer brings the point that at that point in time, pursuant to that statute, other than the posting, there is not a mailing notice that is required at that time. It's basically all about the posting. From what I'm hearing from the protestants and their arguments, is that basically the posting system that is done is inadequate on its face, even if it was complied with, which is perhaps a proper argument, but I don't know if it's one that we need to address. Well, we can address it, but I don't know if we can do anything about it from the board. So as to this posting and notice situation, Mr. Evans, would you like to speak on that, sir?
Well, once again, I mean, the problem, or the sort of overarching feature, I guess, of this case is no one went to the OAH hearing. Okay? We have a record that we're supposed to review for sufficiency. And the record that we review for sufficiency establishes statutory notice, compliance with the statute. I mean, it just does. There's no fact in evidence to contradict that at all. I mean, we are required to review the record, and the record isn't undermined by someone coming in and making assertions about things that aren't available for us to review, number one. So I don't have any problem in the slightest with finding that there was adequate notice. Let me say this as well, though. You know, I mean, there was a lot of extra record discussions here in the case, and you know, it sort of it's understandable why that occurs and why that occurred here. But one of the things that Mr. Rader said or wrote is that he knew about the hearing the day before. Now, I mean, you know, okay, well, I mean, he said he didn't go because you were supposed to give him 2 days notice of your witnesses and exhibits. But I mean, he could have gone, he could have asked for a postponement. He could have said he didn't get adequate notice. He could have said a host of different things. But instead, he did nothing. Again, he did nothing. And so when we have a record that establishes statutory compliance, we have a protestant who, whether it's in the record or not, I don't know if it's in the record, but who acknowledges that he had actual notice. You know, this is all very unfamiliar to me. I'm not used to being quite so adamant in approaching community groups, but again, I have no hesitation. I have no doubt that that the ALJ should be affirmed on this point.
Mr. Lauer, sir?
I agree. I think on the record, there was compliance with the notice, adequate notice here. And I don't think it's our place to write a new statute. Perhaps some of the ideas that were given are good ideas, but it's not our role to say, yes, we should require door-to-door notification as was implied in part of the testimony. I mean, I think the notice was adequate. Okay.
So procedurally for me, I was thinking the problem is if there was no notice and that made sure that lack of notice was the cause that no one appeared at a hearing, then no record could be established opposing the notice that we then could review. So I'm thinking the only way you could attack such a thing is almost in a fraud, mistake, and irregularity type of standard, meaning that you have come to our hearing with evidence showing that there has been a fraud, meaning that pictures are fake or something was fake of that sort, to say as the standard would be for someone to be kept from the courthouse steps, procedural situations that would allow for the fraud, mistake, and irregularity situation for revisiting something that it always has a finality. Again, as you both said, there has been no evidence in the record, and since we are reduced to the record, absent any fraud or anything, mistake, irregularity, it's the timeline that I spelled out before was in the record. That's why Ms. O'Keefe takes photographs of these signs, because this is something that is done to check that procedural box when you're dealing with the notice part of a development plan hearing. So clearly on that factor, if we hadn't already ruled about the failures of the actual appeal itself, there would be nothing for this board to address due to a lack of a record for us to review, because this is not a de novo hearing. And as
Can I ask one question on that? I
Sure.
don't mean to cut you off, but
Sure.
on this, the question of fraud, irregularity, or
mistake,
mistake or something. And this is out of my comfort zone a little bit, but isn't that supposed to be filed with the administrative law judge?
yep, that would be a request for new trial below.
Yes, it's
And-
that's not something we consider
Yeah.
because we don't have a record.
Yeah,
Right.
it's not.
Right, okay.
Yeah, so I was just thinking deep thoughts. Procedurally, you're right, that would be done elsewhere
Right.
before we would even get to it.
Right.
But it's such an irregular situation. When I say irregular, I mean, I've never sat on a case where allegations of faking a notice would be done, but that is not the allegations here are not that there was misstatements about how notice was given. The argument is the way it was done was not sufficient to notify the community, but unfortunately, statutorily, the developer presented evidence that they were in compliance with the statute. They did the posting that they were required to do, and that's all we can review. So yeah, Mr. Evans, as I spoke big words and thinking of ways that we could get to review, you're absolutely right. We couldn't get there without it would first, I guess, be a request for a new hearing below. I guess then we
Right.
could review that.
Correct.
In fact, that were to be appealed, but that would be the first step.
Right.
So I think we're in agreement on that one. The final issue is the CIM postings, which is even a little muddier because, well, we'll just talk about it, whatever. But it's a 32.4.216B1 for the community input. And the statutory, again, language basically leaves it to the county to inform the developer as to the folks who are to get notification via mail. Through the arguments of the developer, I think they gave, I think it was 4 or 5 community folks that were invited, and that information was provided to them from the Office of Planning. I believe the argument of Mr. Rader is that his association was around and should have been invited, and also residents who were, I guess, adjacent to the site should have been given notice, and they in fact did not give notice. So we're back to the chicken and egg situation here again, with this part, which, let me just say this, is that arguments as to this situation, even more so for me, or something that had to be raised before the ALJ.
That's absolutely right. Yeah.
Yeah, so once you say you missed the hearing, you missed not the hearing, but the community input meeting, you missed that. But you hear there's going to be a hearing, that's when you show up and make your argument that you didn't get proper notice to the other. Once that was not done, that issue is not even reserved for us in any shape or form. It seems there is valid arguments as to, the list and registration of community groups, who's in and who's out. It is something you probably might be wanting. But again, that's a statutory construct. It's not really a factual finding per se. But I would have to say clearly on this one, the ship sailed when the ALJ did not get to hear this and make a factual determination on the sufficiency of such. So, and I mentioned this in the argument that basically that at that point in time, we're only, in a record appeal situation. We can't dig deep in things that aren't in the record. So this one was a little easier for me. I don't know if you gentlemen want to comment on that one.
I agree.
Yeah, I agree too. I agree that the the question on the substance, at least as a theoretical matter, would be murkier. You know, on how various community groups are identified by the county and all that kind of stuff. That's sort of an interesting issue, but the ship that had that issue in it sailed, and um, again, there's just nothing for us to review here. I mean, we just don't. There's nothing in the record because no record was created.
Yeah. Yeah. So in summary, basically our threshold issue to give us the jurisdictional, as you intimated, Mr. Evans, for us to review all these other facts, that threshold issue was decided at the beginning of our discussion. These other two issues were fleshed out just in the interest of explaining them on the record, and since we did hear the arguments. So I guess the proper label we should give on this appeal is not that we find against the appeal, but there's actually a dismissal on its face due to failure to comply with the requirements of the BCC. So,
Well, wouldn't we say though, in the event that we're wrong on that, in the event that some higher authority would,
well, we would say, well, I can only suggest is that we do a dismissal
uh-huh,
in the event that we were wrong about such. We will discuss the other two issues. So if we were to receive a remand, the job would be done. Or a appellate court would be able to see our reasoning on the other two issues and make a determination of such. So what you're saying is in any order or opinion that we do, our first is the dismissal. In the alternative, as to the other two issues, we find that the appeal fails and that
Right.
we don't find any mistake in law and defer to the factual findings of the ALJ, nor do we find those factual findings to be arbitrary, capricious, and such in keeping with the statute. So I think that would be the proper construct. The first part being the dismissal, and the alternative finding that we deny the appeal as to the other issues. Basically, that we are affirming
right,
the ruling. And also, as we said before, we didn't even have to get into any type of weight given to an Elm Street analysis because that really wasn't the basis of the appeal, nor is there any record for us to find any fault with the factual finding of the ALJ due to the fact there was no evidence provided to the contrary, and that we find that the evidence through the county agencies elicited through council were prima facie for a development plan approval.
you know, that's absolutely right, and I agree. And the only postscript I would want to toss out here is that the protestants in his filing, he made the offhand comment that he might not even be opposed to this project at the end of the day. And I find it to be a very vexing comment. And I mean, this isn't just a game. I mean, there's a lot of people spend a lot of time, a lot of money, a lot of resources. I'm talking about public people and private people. I mean, you know, this isn't just this is real stuff. So I found that I found that comment to be it made me unhappy, I want to say. So
All right, well, I believe we have done our required duty this morning as to this situation. In review of our findings again, the actual appeal dismissed for its failure to comply And in all the alternative, if an appellate court were to find that the appeal process was in compliance, nonetheless, we have had the hearing and we have also determined that the notice issues as to the hearing before the OAH and notice issues brought forth with the CIM, we found them both, one to be in compliance and the other to be beyond the purview of this record that has been established for us to examine. As to the notice for the OAH, there was a record, meaning that the only evidence that was presented was the postings, the evidence there too, and the emails about where they were posted, when they were posted, and how they were posted. That was not contradicted on the record, thus we can make no other factual inferences otherwise. So that should be that. Anything further from you, gentlemen?
I have nothing further.
No, no, thanks. No,
All right.
thank you very much.
See you all. Bye-bye.
Bye.